my lady, my lords. I appear in this matter with my learned friend, Mr. Smiley. My learned friends have the advantage of being represented, the claimant has the advantage of being represented by Mr. Burns, King's Counsel, and Miss Greenley. My lady, there are two main points in this appeal, and there are a plethora of much more minor points. The two main points in the appeal are first in relation to causation, that we say that despite being given every possible opportunity, the claimants have not pleaded an intelligible case on causation by reference to their originally pleaded allegations, or indeed, if relevant, to the amendments. Secondly, that in seeking to meet our complaints in relation to causation, they have impermissibly sought to add new causes of action after the expiry of the limitation period, which do not arise from the same or substantially the same matters which factors were already in issue. Those are the two main points. They overlap to this extent that when one has to look at the history of the relevant matters, instead of dealing with and focusing upon causation, what one sees is changes to the underlying allegations. And with your permission, I shall spend a very little time just tracing the history through so that you can understand how that takes place. It's also relevant directly to some of the points which were made by my learned friend in their skeleton argument, including in particular that we didn't challenge causation until 2020, when in fact we did. The host of plethora and minor points are the inconsistencies and uncertainties as to what the claimant's case actually is. I'm not going to run through all of those, save that I shall refer to some of them in passing when we look at the documents. Their relevance in our submission goes to the need for clarity in relation to causation and understanding what is and what is not alleged against us. The way I put those points are against the background of the long period of time which we've had in which this action has been gestating. Perhaps any one of them wouldn't be of any importance, but looked at as a whole, the picture is profoundly unsatisfactory. So that's how I put the case.
Thank you.
Can I just identify in relation to causation our central complaint? Our central complaint is that we do not know how it is said that the breaches which are alleged against us is said to have caused the damage which is complained of. Now, there is obviously a different intellectual question between how and what. So far as the what is concerned, the damage which is alleged against us has, as we shall see, changed on quite a few occasions. It's still, frankly, completely unclear as to what it is that's alleged against us. But there is at least some pleading in relation to the what. The how, we say, is simply not there. And with respect to the learned judge, if one just goes to his judgment at paragraph 40, which is where he deals with the conclusions in relation to our complaints on causation. If one looks at paragraph 40, he says that in his judgment...
So, do you mind giving a page?
Oh, I'm sorry, sorry, my lord. It's tab 6 of the core bundle, page 62.
Thank you.
And I was looking at paragraph 40. What he says is that, in his view, on a fair reading of the draft re-amended points of claim, the pleaded case on causation is clear. And he says, in my view, the defendants should each understand what the claimants say they should have done, but failed to do, or did but should not have done. Well, to make the point, obviously, that's a case on breach. It's got nothing to do with causation. They should also understand what losses have arisen as a result. Well, that is a case of the loss, it's therefore the what, not the how question. At its heart, GT's case is that it was ideally placed to enjoy very substantial profits from its sole and exclusive rights to sell a valuable, highly sought-after product. Well, that, again, is a what. If Rouse and CDs had not acted in the way they did, and then this, effectively depriving the claimants of its rights, those substantial profits would have been realised. Well, the only part which goes to how of this is effectively depriving the claimants of its rights. And with respect, when one then looks at the further analysis, that is wholly insufficient to deal with the how question. And he then goes on to say he accepts, it seems to me the claimants accept the plea that it could be simplified. And then his reasoning is paragraph 41. He, reaching that conclusion, I take into account at least those parts of the schedule of loss, part B, I have referred to. Now, just so that we're going to be going to the schedule of loss when I go through the history very briefly, but in terms of what it is that he's referred to previously in the schedule of loss, you get that at page 56, paragraph 9. Where the judge says a schedule of loss was also prepared on the 17th of February. He refers to the request for information where we'd asked for particulars of the quantum of each and every head of loss. At paragraph 11 of the schedule, under the heading Preamble, the claimants noted on the 5th of February that they granted exclusive rights to the quarry. Now, we'll look at that agreement in a minute, but 2 points at this stage. That preamble is a series of facts. It's in Part A, paragraph 11 is in Part A. So if you just go back to what the judge says at paragraph 41, I'm satisfied I take into account at least those parts of the schedule of loss, Part B, I've referred to. So it looks as if he's not referring to the agreement of the 5th of April 2011. And the only other parts he refers to are the schedule of loss pleads loss under 6 heads, and A, B, C, D, and E are set out. And those, again, are all what? They're nothing to do with how. And we'll see that when we look at the schedule of loss in a minute. And then he says, there's no doubt in my view that the schedule of loss is intended to be read with the draft re-amended points of claim, and it'd be wrong in my judgment to consider the draft re-amended points of claim without it. Now, my lords, you'll have seen our points, that at no point during the argument was it suggested that the schedule of loss actually provided the answers. It wasn't relied on. It's actually inconsistent with the loss which is now claimed. But in any event, our key and overall point is whether you look at it or not, it doesn't actually help in relation to causation. And then the judge goes on, even if I'm wrong about that, the draft re-amended points of claim at paragraph 11 make plain that GT has lost the opportunity to make profit from the exclusive right to sell the profit, 111A and 111E. And so if we just look at the judge's reasoning, a look at the draft re-amended particulars of claim, which is at tab 9, and the relevant paragraph for paragraph 111 is at page 131. The judge refers to little a. The first claimant has suffered loss, including but not limited to.
Sorry, what page you on?
Sorry, page 131, my lord.
Yes.
Paragraph 111A of the draft amended particulars claim. This is under loss and damage, and the paragraphs the judge are referring to is 111A, which is the one I'm looking at. Including but not limited to, the first claimant lost the entire business, including the exclusive sale marketing. Well, again, that's what, it's not how. And E, the first claimant lost the opportunity to market, sell and distribute the Geo-Minerals product produced by the quarry, and the associated profit would have been made through those lost opportunities. including but not limited to, and then Gulf Petroleum, 5 million investment, 2.9 million deal with renewable profits, collaboration with ITD International, and the US distribution agreement with Ed Machado. Again, that is with the what, not the how. And then paragraph 42, for those reasons, the grounds for resisting the amendment for disposing the claim has nothing in it. So with respect to the judge, just looking at what he says and what his reasoning is, there is simply nothing which deals with the how question in what we have put forward. Against that background, I am, as I alluded to previously, going briefly to look at the history. The purpose of looking at the history is that the court has clearly in mind what the original allegations were, when the complaints were made, and what has been said. And I'm going to deal with it reasonably quickly by reference to the key points, but that's why we're looking at this. As you know, the claim form was issued in April of 2018. On any view, right at the end of the limitation period in relation to complaints which were made, and now over 5 years ago. The original claim form, at paragraph 7, was issued in April, and it was amended prior to issue pursuant to Rule 17.1(1), which is the rule which allows for amendment prior to service of the claim form. And if you look at that claim form, you'll see the brief details of the claim. Little 1, the claimant's claim is for damages for breach of contract, professional negligence, and in the claim form, dishonest assistance. The reason I show you that...
Can I have the page, please?
Terribly sorry, it's the second time I've been guilty of that. Tab 7, page 72, my lady.
Thank you very much.
The reason I'm showing you that is that one of the main complaints that we make about the amendments which have been introduced is that they introduce a case for the first time, so far as we're concerned, of deliberate breach of duty, deliberate breach of a conflict of interest duty. But what you see here is that originally in the claim form there was a claim for dishonest assistance. That's not proceeded with in any of the matters, and indeed, as we shall also see, it's specifically confirmed that the only cases made against us are for breach of contract and professional negligence. But originally in the claim form there was this nebulous dishonest assistance claim hanging around. It's probably obvious that in due course we will be saying that one of the most unsatisfactory features about this is that there are allegations of deliberate wrongdoing which are now sought to be introduced by way of amendment, not in the amended particulars, but which were preceded by this. And then they added the claimant's claims for damages for conspiracy to injure by unlawful means. You'll have that already, but that, added by amendment to the claim form, doesn't concern us. That's the claim against the conspiracy defendants. Then what happened is that there were the particulars of claim, which we have at tab 8, page 75. Now, you've probably picked this up. These were not actually amended pursuant to Rule 17.1(1). What actually happened is that we were served the original particulars of claim just before expiring for 4 months. The parties then agreed that as there had been no pre-action process, there would be letters exchanged. The day before our letter of response was due, we received these amendments, and we pleaded in our defence to this, including the amendments. The technical position is therefore that there's never been an order dealing with these, but plainly I can't proceed on anything other than that these amendments we haven't objected to, we've pleaded to them and so forth therein, but just so that you know what the factual history is in relation to them.
So there was never formally an amendment?
That's correct.
So the title draft re-amended is confusing.
Yes. I mean, if I'd had my time again, I might have made some complaints about these, but I make it plain I'm not doing so, and just so that you understand why the documents are in the form we've got here. Now, the key points about these particulars of claim, and I'll take you through the relevant parts in a minute, is that they plead a meeting in March of 2011, at which they say that we were instructed to transfer certain intellectual property rights to the first claimant, GT. They plead that we did that, and they then plead that a year later we acted in breach of contract or negligently by transferring the trademarks from GT to Holdings, the first defendant. And they also make a complaint that we drafted a document which was an assignment of the entire business. We say in our defence that that was a mistake. It was an American trademark document. But anyway, that complaint is in there, as we shall see. And that's it, so far as the complaints which are made against us in these documents are concerned. And I'll take you through and see that. There are certain other matters which are referred to as matters of history and so forth, which are now sought to be relied on. But the actual complaints which are made are limited to those which I've just identified. And as we shall also see, when we get to the causation, we have nothing, and when we get to the damage, we have very limited information. Now, the relevant paragraphs, so far as we are concerned, the first paragraphs summarise the claimant's claims, and at paragraph 3, you'll see that a complaint which is made not against us, which is an unlawful interference claim in relation to KD, and KD is Kevin Downing, the second defendant. And then paragraph 4 summarises the claim against us. Now, at that point, they adopted an omnibus approach and sued a whole load of companies, but you'll see that the relevant paragraph is that the Rouse entities, and they include the fourth defendant, which is the sole amending defendant, was instructed by GT to register relevant trademarks in the name of GT. Rouse acted beyond the scope of instruction by arranging the transfer of intellectual property rights and/or sale and distribution rights as between GT and Holdings, in circumstances where no authority or instruction had been provided, etc. Further, they drafted and arranged the execution of documents which transferred the entire business of GT to Holdings, in circumstances with no authority, etc. had been instructed. In so doing, Rouse acted beyond the scope of any contractual retainer, failed to act in accordance with the standard of reasonable skill and care. So that's their summary of the claim against us. Then what happens is that there is a long series of background matters, and most of the background matters which are set out are not involving us. Of relevance for present purposes is that paragraph 5 pleads that Colin Tennyson was a director owning of another company, Geotech Construction, and that company was involved in the quarry excavation business. You'll see at paragraph 7 that the first defendant, GT, was set up and it was to be involved in marketing. And then if one goes through to paragraph 11 and 12, you see that at 11, they plead that CT and Mr. Gormley were introduced to Mark Foreman, a solicitor based at Rouse Co in London. That's corrected. And then 12, at a meeting which took place on the 29th of March, the following persons were present. At that meeting, notes were taken, and then this MF was instructed by GT, CT, and MG to register relevant trademarks. No authority was provided at the meeting or separately to register trademarks in the name of any other entity. So they're saying March 2011, we were instructed to register trademarks. Then you see a paragraph 17. We did that. We registered the trademarks in the name of GT, and 18, they identify what those trademarks are. Then they plead, at paragraphs 19 and following, a whole series of lengthy negotiations. And those negotiations are, in short summary, various different arrangements which were being contemplated between the claimants and the conspiracy defendants, on the other hand, to deal with the various rights. And you'll see, for example, that at paragraph 24, there's a reference to entering into discussions with Chinese investors. Paragraph 25, you see references to obtaining licenses and so forth. And it's not alleged anywhere in any of that we are directly involved. However, in paragraph 29, you see that in March 2012, so you see we've gone forward a year, that Mr. Wayne of Pretty's, acting on behalf of Holdings, made an offer. And one sees what's said about that. And then that's followed in paragraph 30 by a letter of intent. And then this in paragraph 31, in 28th March 2012, Mr. Foreman, that's the gentleman who's been identified previously as the solicitor of Rouse, emailed Ian Wayne confirming an instruction to draft heads of terms and crucially instructing the contracting party would not be GT, would be Holdings. At that time, Holdings didn't own any of the rights, etc. Then one sees other documents as to negotiations and so forth going on. And paragraph 39 pleads allegations in relation to a meeting with Mr. Machado in California, and they allege in paragraph 40 that there was a fear, effectively, of a behindhand deal being done. And then paragraph 41, unbeknownst to GCL, GT, CT, and NG, so they're saying unbeknownst to the claimants, effectively, instructions were provided to United States attorneys via MF to prepare assignments and trademarks of the entire business of GT to Holdings together with the assignment documents. And then paragraph 42, they were each signed and purportedly executed by Mr. Baines on behalf of Holdings, and they were purportedly signed and executed by Mr. Gormley on behalf of the GT. So what they're saying here is that there's a whole series of documents which are executed purportedly on behalf of Mr. Baines, who's one of the conspiracy defendants on one hand, and Mr. Gormley, who's effectively acting on behalf of GT on the other. And then paragraph 43 alleges that Mr. Gormley's signature was forged. And paragraph 44 alleges that Mr. Kevin Downley didn't witness the signature. So in other words, what's being said is that in relation to the assignment documents, they're forged both in terms of the principal and the witness, who are alleged to have signed on behalf of GT. And that's made good in paragraph 45, where they make it absolutely plain that on their case, they had nothing to do with any of these matters, and therefore, end of paragraph 45, they're susceptible to a plea of no nec facto. And of course that's right, if they were forged and the relevant documents were forged and the GT isn't bound by them. Then paragraph 46 is a whole series of other allegations. They've got nothing to do with Rouse at all, but they are relied upon in support of the alleged conspiracy. Paragraph 47 involves alleged contact directly between the conspiracy defendants and the claimants and alleged false representations. Paragraph 48 alleges that it became apparent that there had been a wrongful transfer, or unauthorised transfer of the Omri licence. Again, nothing to do with us. Paragraph 49 is then the offer from Gulf Petroleum. Paragraph 51 is an allegation of unlawful intimidation against the conspiracy defendants, followed in paragraph 52 by the withdrawal of the offer. Then you see that in paragraph 55, they identify effectively that they found out that the trademarks had been wrongly registered. And paragraph 56 then says that they wrote to one of the Rouse entities identifying the following, and a further letter at paragraph 57, all complaining effectively about the trademarks. Paragraph 59 deals with correspondence asking questions as to how we were able to act on behalf of GT and Holdings and about the role of Mr. Foreman. Paragraph 60 shows that we referred to the assignment, and paragraph 61 refers to some correspondence about taking down the website, and paragraph 62 identifies that we provided the assignments to them. So they become aware that trademarks had been registered in the summer of 2012. There's then correspondence, and by the end of November of 2012, they've been given by us the assignments upon which we had acted in transferring the trademarks and so forth. Then paragraph 63 reiterates that Mr. Gormley didn't sign any of them, really already been done. And paragraph 64 identifies that we were told about that. And paragraph 65 cites from a letter from us identifying what our case was as to how it was that the assignments had been executed. And then paragraph 67 is the start of the complaints which are actually made against my clients. Paragraph 67 is that we didn't advise or seek instructions prior to drafting the assignment documents. We were aware that GT was a separate entity. Paragraph 68 says that we were aware, or ought to have been aware, that GT had only ever instructed Rouse to register trademarks in the name of GT, originally on a temporary basis, but then with a change to that in red. No instructions to assign trademarks, drafting assignment documentation without the express authority was outside the scope of the retainer, and then lack of authorization. And then paragraph 70 is for the third time that each of the assignment documents was false and forged. And then one sees that the conspiracy defendants issued a claim against GCL GT CT alleging that binding joint venture agreement had been created. We actually know from other documents that those proceedings, the Northern Irish proceedings, were started in July of 2012. But that's how it's pleaded here. And then the particulars are first of all a conspiracy to injure by unlawful means, not made against us, and what they allege is a wide-ranging conspiracy which is identified, including, for example, little 2, the provision of the forged assignment documents to us. So they're saying they conspired to do various things, including provide forged assignment documents to us. And then they rely on various different matters in 75 as to why they should, the conspiracy documents should be inferred. And then, so far as we're concerned, The breaches relied on are at page 94, paragraph 78. We go back, first of all, to the meeting of the 29th of March, paragraph 78, which has already been pleaded. Paragraph 79 reiterates that we are only ever instructed to register trademarks on behalf of GT. Paragraph 80 says we became a client of Mr. Foreman and Rouse, and a contractual retainer was created. 81 is that we acted beyond the scope of instruction by transferring these intellectual property rights in circumstances where no authority of instruction had been provided. 82 is the execution of documents which transferred the entire business. 83 is assignment documents again. 84 is that we ought to have been aware that GT hadn't provided authority or instruction to create them. And then 85 says that we owed contractual common law duties as a solicitor acting for a client. Those duties included a duty to act within the scope of any instruction or perform services in accordance with the professional standard of reasonable skill and care, and then reiterates we acted beyond the scope of the journey. And the complaints is the breach of authority has caused loss or damage. And 88, little 1, the first claimant has lost the protection of valuable trademark rights and intellectual property rights held by GT. Well, you will immediately see that against the backdrop of the reiterated plea of non est factum, one is saying, well, how have you lost those trademark rights, given that your case is that they were forged? On the face of it, 88 little 1 makes no sense. Little 2, the first claimant has lost the economic value of those trademarks and intellectual property rights. Again, on the face of it, they've known about these being registered elsewhere since since August of 2012. They've had the actual assignment since the end of 2012. How does this work? And then the first claimant has lost the opportunity to market, sell and distribute the general minerals product produced by the quarry. Well, again, how does that work against the backdrop of this? Lost the profit associated with marketing and selling, incurred costs of management time, incurred costs in defending proceedings. Now, that's the claim which is brought against us. In relation to the defence, we take a series of entirely predictable points, but relevantly for present purposes, at tab 11, page 188, at 109 little 4, we plead the plea of loss and damage at paragraphs 88, 1 to 6 is embarrassing for lack of particularity. The claimants have failed to plead the quantum of any head of loss and how any such head of loss has been caused in fact or law by the alleged breach of duty by the Rouse defendants. And then we spell it out. As pleaded, it's premised on the alleged transfer of rights owned by GT, and we make some points about that. And then we identify what marks were actually transferred. At 109.8, we make the point about the conspiracy and that being the operative cause. And then at 109.9, we say that on the basis of the claimant's own case of conspiracy, either conspiracy and forgery, the claimants have suffered no loss as the alleged transfers are void or voidable. So at the same time, that's not true, very, very shortly after the defence is put in, we put in a request for further information. And we're now in the early part of 2019, so some 4 years ago. And although the request for information is sought to be pursued, there are a series of extensions of time are granted, and the first time it gets answered in November of 2019. So we've gone forward now a year, more than a year from when the proceedings were issued. And materially for present purposes, if I could ask the court to take out the supplementary bundle, go to tab 2 and go to page 12 of the supplementary bundle, we get confirmation at request 3.2 that it's not alleged that any of the Rouse defendants knew that MG's signature on any or all of the documents was a forgery. And in relation to the loss and damage, sorry, in relation to the causes of action, at 20, page 20, 18.2, we asked for confirmation the only causes of action were breach of contract and professional negligence, which was confirmed. And then 19, we asked for particulars of the quantum of each and every head of loss, how each and every head of loss is said to have been caused or in fact by law, and the response was they will serve a full schedule of loss. We then pressed for proper answers to the questions we've been put forward, and we were served further particulars which materially don't change the case in February of 2020, which is at tab 3.
Should we note there, Mr. Stewart, that 19.2 says the schedule loss will also address causation?
Yes, sorry, I should have pointed that out, my lord, yes. And what then happens is that we get further particulars which are in fact in tab 3. They don't alter anything for present purposes, but those particulars were served with a schedule of loss, and you find the schedule of loss buried in the documents at tab 25 on page 218. And this document was served in February of 2020. And what you see here is, first of all, a preamble under the heading of Part A. So that's coming back to the point I made about the judge's judgment about what is and isn't being referred to. And you see a different, as it were, set of facts being relied on by way of preamble. And you see at paragraph 11 the document which the judge referred to, which is on the 5th of April 2011. Geotech Construction provided the first claimant with exclusive rights to the quarry and to market the product in Northern Ireland and overseas. So that's the pleading of the 5th of April 2011 document. Now, that document, it's convenient just to look at it for present purposes, is at tab 53 on page 282. We refer to it in our skeleton argument. You'll see that what it says is that Geo Construction Ltd, the owner of the quarry, irrevocably confirms that it grants Minerals, first claimant, to the exclusive right to purchase material from the quarry at a price to be determined, which will initially be not less than 15 pounds per tonne. Extraction and processing is going to be the sole responsibility of Geotech. And then there's some obligations. Transfer pricing between Geotech and GT will be reviewed annually on the anniversary of this agreement undertaking, and subject to agreement between the parties will be adjusted accordingly. And then there's a minimum output of 15,000 tonnes per month. And the points we make in our skeleton argument are obviously this looks like an agreement to agree. It's wholly unclear how it's actually going to be operated.
It's a maximum output, isn't it?
Sorry?
It's a maximum output, isn't it?
Sorry, maximum output, my lord. I said minimum. Sorry. Yeah. The point we're making is that it's at a price to be determined. It's an agreement to agree and so forth. And how it fits in, as we'll see with the schedule of loss, becomes very difficult to understand. When one looks at the preamble, one sees, sorry, I'm going back now to tab 25. You see a different account of events taking place. And if one looks over to 220, one sees at paragraph 18 the document I referred to earlier, which is the Northern Irish writ being issued in July of 2012, which is for claimed breach of the joint venture agreement. And then one sees in paragraph 20 the receipt of correspondence from the conspiracy defendants alleging they were registered proprietors. Little b is an assertion we wrote directly to the claimant's web hosting companies, and that's it. So you've got a preamble, you've got no express dealing with causation at all, despite, as my Lord Justice Phillips made the promise one would do so. And then you get the damages and loss and profits at 221. The first is loss of profits from the Q3 2012 to Q4 2013. So we're looking here at 2 years and 1 month's worth of profit, which is said to be £23.6 million. And what they say is that there was a reserve of approximately 6 million tonnes. Whilst the claimant was able to mine 50,000 tonnes of the product each month, he could only export 15,000 tonnes of the product each month. By July, the claimant had stockpiled 65,000, had 13,000 tonnes, and then there's a table which shows the alleged profit. Now, it's unnecessary to look at the detail of it, but this looks like the total profit which is being put forward. In other words, it appears to take account of costs from GCL. In any event, what this is plainly the what, not the how. 223 is then item 2, which is an alleged loss of a 3-year US contract for $9 million. And then item 3, the lost profits the business would have received from 2014 onwards had the business not been lost, calculated on the full reserve, estimated at 6 million tonnes. Loss of intellectual property rights to be confirmed. Damage to reputation to be confirmed. And then, by way of slight contrast to the telephone numbers before, the sum of £851.92 on page 225, which is the full reimbursements of any and all professional fees and reimbursements paid to Rouse. What that actually is has never been clear, but that's what one's got. So you've got February 2020, a schedule of loss which doesn't deal with causation at all, is utterly opaque about the very large telephone numbers which are being claimed from 2014 onwards, and where how the sums are actually made up against the background is completely unclear. In other words, the what is unclear, but the in any event the how is simply not addressed. We then complained about this matter. You see that in our letter at tab 26 of the 26th of November of 2020. And at 1.3, we complain causation hasn't been satisfactorily addressed, contrary to the position adopted. No positive case has been advanced setting out how the losses alleged to have been avoided, but for the breach said to have been committed by Rouse. You'll appreciate it will be your science to establish those alleged losses wouldn't have been suffered in any event, and we make a series of points about that. And those points include points at 1.5.2 about the July 2012 writ in Northern Ireland, the fact that they were in a position to challenge the assignments from August 2012, and so forth. Now, plainly, the trial of those issues isn't a matter for this court. But what we would respectfully submit is that we are entitled to know a clear view as to how it is that these alleged breaches have led to these sums being claimed. The eventual response to that is given in March of 2021 at paragraph tab 28, and the causation response is at 239, paragraph 4.1. Sorry, I've skipped forward. Sorry, I gave you the wrong reference. Sorry, the response to that is at tab 27, 230. On causation, they say expressly denied with the particulars, etc., that your client purported to transfer. In doing so, your client caused substantial loss to our clients because they were unable to conclude contractual arrangements with third parties whilst there was any dispute over or doubt regarding the right of GT to the intellectual property in Geo-Minerals business, including rights of extraction. These losses are set out within the schedule of loss. The case is sufficiently pleaded and further explained below. And the further explained below is the reference to what is said paragraph 2.3, where they say it goes without saying that but for the breaches, our clients would continue to own the entire business and all intellectual properties. Your clients' co-defendants wouldn't have been able to communicate, etc. Now, at this point, we thought that we were getting somewhere in relation to causation, and so we responded to that in the letter at paragraph 28, tab 28, 239. Um, 4.1, while a vague case on causation and now loss has now been advanced, as we extend on below, this is set out across numerous different documents of varying status, inappropriate and entirely unsatisfactory for your client's case to be set out in this manner. And then we make complaint about how it is said to be identified, and we make the point that any judge seeking to determine this matter is likely to encounter significant difficulty in having to interpret your case, and inappropriate for case on causation to be set out within Part 18 responses, the schedule of loss, etc. We make the point that they don't have permission, and that paragraph 9.2 objects to matters which are inconsistent, and we make the point that there are a number of matters which are not covered in the amended particulars. And we therefore say in paragraph 4.3 that your client's case on causation is inadequately pleaded, it should be addressed by way of further amendment, and invited confirmation that your clients will seek to re-amend their particulars of claim. So, March of 2021, we're saying we've still got complaints. Your letter sets out a vague case on causation. It needs to be properly pleaded. Please provide us with amendments. What then happens is that there is very substantial delay. Part of that delay, as you will have seen from the papers, is due to the fact that the replacement counsel for the original counsel who'd been instructed by the claimants suffered from a terminal illness, and that was explained to us in correspondence, and that was dealt with. But in any event, the consequence was that it was not until the late autumn of 2021 that we received the draft re-amended particulars of claim. And it is against that backdrop, therefore, that we look and see what the draft re-amended particulars of claim does. Now, the draft re-amended particulars of claim, which was before the judge, is to be found in the main core bundle.
It's 9, isn't it?
Sorry, Melody.
It's 9.
Yes. Now, just to avoid any subsequent mix-up, this was what was before the judge. It's got in green the amendments which were sought against the backdrop of the red, which I've already explained. There is a document at tab 10, which is the revised re-amended particulars of claim, which was after the judge's order. Now, we don't need to look at it for present purposes, but just in case any of you go bundle diving and look at it with a bit of question marks, it was served by the judge pursuant to the tidying up. It does not comply, contrary to what my learned friends say, in certain respects with what the judge himself ordered. The most obvious being that the judge said in terms that allegations which were including but not limited to were not to remain in. And if you look at the document, you will see that it has got including but not limited to within there. If we get that far, there will have to be a fight about the extent to which that document actually complies with the judge's order. But for present purposes...
Should we just deal with what we're really good at dealing with?
Well, I was only dealing with this because it's in the core bundle, my lady, and I was concerned that you might want to know what the status is. For present purposes, I say it's irrelevant to you, which is why I was giving you the brief introduction which I've just put forward.
You say it has no status. It's not the document the judge required, and necessarily there'll have to be an argument about that some other day.
I do, my lady. That's all I say about it for present purposes. Just for fullness, also contains a couple of new allegations, but as I say, we don't need to look at that. Now, what this does is substantially recast the case against my clients, and the amendments comprise a number of, we say, significant changes, but the overall effect of the changes which have been made is to transform a case, a limited case, about complaint in relation to the assignment documents, which had been identified, as we've seen, in the amended particulars of claim, to a much more onerous case alleging deliberate breach of duty by my clients over an extended period of time. So that's what we say is occurring in relation to these matters. And we start seeing the changes starting at paragraph 10 on page 101. And what you see in paragraph 10 is that before the first discussion of the March 2011 document, there is discussion between the parties, and then at paragraph 11 there's reference to a marketing trip to India. Paragraph 12 pleads very considerable details as to the March 2011 meeting, which weren't previously present. And then at 103, you see, perhaps just before, on the 22nd of March 2011, Rouse filed the trademark application on behalf of Draven. Well, there's never been a previous complaint about that. CD telephoned MF to arrange a conference at Rouse's offices the following week.
Sorry, what are you reading from?
I'm reading, my lord, from the bottom paragraph of page 102.
Yes, thank you.
And then little g, all communications with Rouse, including the filing of the application in the name of Draven, have taken place without the knowledge or consent of the claimants or MG. The application appears to have been deliberately concealed from the claimants and MG. Now, it's unclear at present whether that's an allegation against us. It's not expressly pleaded. Read fairly, in my submission, it could only be on the basis that had been deliberately concealed by the conspiracy defendants. Then one sees the claimants were contacted by KD and the CD, who suggested that in order to protect the trademark, etc., they ought to register. And then at 13, one sees details of the March 2011 meeting. And at 13.4, one sees a complaint. MF didn't mention or reveal that he'd received instructions from Draven the previous week, or that he'd acted on those instructions. MF didn't advise of a possible conflict between GT and Draven, nor did he mention that he'd been in communication or dialogue with CD the previous week when CD was in India. So what this appears to be setting up is what comes subsequently in relation to deliberate breach of duty. 13.5 are allegations of failing to provide due diligence, not providing the claimants or MG with a retainer letter, not requesting a copy of the claimant or MG's signature, not asking for a letter of authority, etc. And then there's a reference to an admission at 14 and 15. Now, this is all substituted for what had been there previously. Then at 105, there's a reference, paragraphs 16, 17, and 18, to drinks which took place and which are not alleged to have involved us. And then at paragraph 24, one gets a new pleading that Pretties were purportedly instructed on behalf of GT in relation to various possible commercial transactions, including the drafting of an NDA between Peter Hambro, etc. Neither the claimants nor MG or GCL instructed Pretties to act on behalf of GT, nor were they aware that Pretties had been instructed on behalf, as they will have their own solicitors, etc. And if we then go forward to page 114, paragraph 57 gives some further particulars of the alleged investment in relation to the GT holdings following the Gulf Petroleum offer. And 62 is then important because at 115 there's a plea that on the 14th of August, Connor Tennyson contacted Rouse to complain, advised he wasn't available. According to invoices, Rouse contacted the US trademark and warned him he might receive a call from C2 in relation to the trademarks. The purpose of this call was to ensure the assignment to the trademark and entire business from GT to holdings took effect. And then if we go forward to where we get the further matters, paragraphs 80 and following at 120 are all in relation to statutory demands and so forth. Those statutory demands start off by proceedings being issued in July of 2013, and you then get some pleas about amounts per hour and processing and so forth at 91 through to 94. So far as we're concerned, the breaches which are said to take place start against us at page 125. They change the allegation that we're a solicitor to a trademark attorney, which is fair enough, because we are a trademark attorney, not a solicitor. And then 104 pleads new duties, and you see that from 105, which refers to Schedule 4 of the Legal Services Act and the TMA Code of Conduct, and the pleading in 107, Rule 4 is competence, and then Rule 5 is integrity. Regulated persons shall at all times act with integrity, putting their client's interest foremost, subject to the law and any overriding duty. And then Rule 7, pleads expressly rules about conflicts, must not act whether its interests conflict with those of a client or a former client. And then in 108, we get the new breaches. Little a is in November 2011, a complaint that we provided instructions to British solicitors in order to arrange for the NDA to be drafted. Never previously the subject of complaint. And they say, in the NDA, CD is held to be a director of CT and both CD and KD to be shareholders. MF and Rouse knew neither to be the case. They didn't have instructions from their actual client. B and C are about, B is about trademarks. C is an allegation that in March 2012, we instructed Pritties to amend the Machado draft heads of contract. D is about trademarks. And then E says that acting contrary to the interest of their client, we said that Holdings was the successor when we knew or ought to have known that was untrue. And then they, as it were, amplify the allegations against us at the top of 129. Rouse repeatedly failed to communicate its knowledge of actions taken to the detriment of its client and knowingly created a conflict of interest in acting for Draven GT and Holdings. So just pausing there, that is an allegation, an express allegation of knowing wrongdoing, which has been set up by the changes which have been made to the particulars beforehand. And then this is in the breach section. Had Rouse alerted GT to the actions of CD, KD and Holdings, it would have taken steps to prevent the fraud. Now, insofar as that is a plea in relation to causation, it's limited to a new plea which is being put forward. It begs the question of when are you saying we would have alerted and what would they have done? Always bearing in mind, as your lordships and your ladyship know, that they'd already got the trademarks and so forth in August of 2012, and that they had the actual assignments by the end of 2012. And then K is also an allegation of deliberate wrongdoing. Further, Rouse actively sought to advance the interests of KDC and Holdings to the detriment of their client and in conflict of interest to GT, including but not limited to, and then we get instructing Pritties to replace GT, despite knowing that CT had called MF to complain on or around August, contacting Terry Miller, emailing links of the claimant solicitor's website, emailing overseas agents warning them possible rejections, sending a letter in relation to the website, sending a letter to the web hostings, etc. And then L, still in the allegations of breach, by its actions, including but not limited to the forged transfer from GT to Holdings, Rouse provided an authoritative public platform to routinely make representations to third parties that they owned the entire business. Now, it is worth just trying to understand that. They've already alleged against us, in the original particulars, that we'd wrongly transferred the trademarks, and they've said they were forged. The Trademarks Register is a public document. If they've got a case that we did that, we were the victim on their original case of a forgery, someone looked at the Trademark Register and that had some particular consequences, well, that's a case that we can, as it were, at least understand. But this allegation, in the context of breach, is obviously different from that. It's saying that by its actions, including but not limited to the forged transfer, well, they've already told us that we don't allege we knew of the forged transfer. So are they now withdrawing that? Is that different? What is being said here? But if they're not withdrawing it, what does it add? And then one gets, for example, KD contacted Gulf with unsolicited correspondence and telephone calls claiming title to the business. KD and CD interfered with the deal, etc. Now, this isn't a merely sort of technical point. We've been badgering on about causation for ages, and this is a new particular of breach. So what is it that we're alleged to have done by way of breach? And one sees...
Well, you asked the question, what does it add? Isn't the answer that it doesn't actually add anything other than flesh out what the conspiracy defendants were enabled to do by the registration of trademarks in the name of the wrong entity?
Well, my lord, if that's what it was intended to do, what you would expect to see is that in relation to causation, had we not arranged for the transfer, the assignments and so forth being put forward, then the following would have occurred. Not to add this as a new allegation of breach in subparagraph L. And we then get acted beyond the scope of any authority and the TVM Code of Conduct, which is wrap up in 109. And then in 111, as a result of the conspiracy, unlawful interference and Rouse's breach of contract, the first claimant has suffered loss and damage, including but not limited to, the first claimant lost the entire business, including the exclusive sales. And the first claimant no longer held the honorary license in little d. And then we get in little e various different points which are being put forward. And little h, the second claimant being an individual, sorry, H and I have gone, it's accepted that H and I have gone, that's a bad point. Now, insofar as the rest of these are concerned, it is entirely unexplained how the loss and damage at 111 and following relates to the schedule of loss which was served in February 2020. In other words, they served this at the end of 2011, almost 2 years after the original schedule of loss. What is said here is inconsistent with that. So in terms of what the actual what is, we don't know how they relate. But more fundamentally, we say that we are still left with an unintelligible case in relation to causation. Now, my lords, that is something of a whistle-stop tour in relation to the history of the matters before the judge, so that you can see how they got where we've got to now. What I propose to do now is to make some brief submissions in relation to limitation and the appropriate approach to limitation in relation to the new allegations. And it is, I think, common ground that the appropriate framework is to follow that which is set out in our skeleton argument in relation to the legal principles helpfully identified at Diamandis at 49.
And just before you leave causation, isn't the essential case made in this document, never mind the schedule of loss, which appears to have been overtaken by this document, that as a result of the trademarks being registered in the name of the wrong entity, the conspiracy defendants were able to scare off people listed in 111E, who would have enabled the claimants to make a lot of money.
Well, my lord, what I'd say about that is if after 5 years that really is what the case is in relation to the original allegations, one would expect it to be identified clearly by reference to that and by reference to the use being made of the trademark and other assignment documents, not to be, as it were, wrapped up in the way that it is sought to be wrapped up, and I've shown your lordship just now.
I mean, I can see it might be a very weak case. Don't say anything one way or the other about that, but isn't that what they're trying to say?
Well, my lord, ultimately it's a question of fact and degree. We've cited the authorities which require clarity in relation to pleadings and certainty as to what the case should be and so forth. I said there are a whole series of little points. We've identified at paragraph 25 of our skeleton argument, inconsistencies and so forth which are there. But in terms of bigger points, if that is what their case is, then you would expect on a macro level to have the original breaches identified together with an identifiable section headed causation, which says, had they not done this, then the following would have occurred. You would also expect it to be identified how it is that the actual assignments of which they originally complained, the trademark assignments and the business assignments, were actually used. And you would expect also, and this comes back to a point which is made by Mr. Justice Coulson in the passage which we cited in our skeleton argument from Pantelli, that when you are identifying what you've done wrong, you need to identify what did happen, but also in your case what would have happened, what, in other words, what the counterfactual situation is. Now, are they saying that had we not done this, had we not drafted the assignment documents, there wouldn't have been forgeries, there wouldn't have been allegations? What is their case about the counterfactual? My lords, ultimately, one has to, in my submission, to look fairly at the pleadings against the background which I've put forward and says, does that fairly provide us with what we need to know? I would accept, my lords, that if we were some 4.5 years ago and one was trying to say, well, you know, could there be a case here? That would be one thing, but your lordship will have seen from the background that this isn't a case where we've rushed to court to try and deal with the matters. It might be said we sat on our hands too much, but that's a different matter. I was proposing, unless there's anything else on causation, to move on to limitation. Do. So far as limitation is concerned, the starting point is there a new cause of action? And then obviously the second limb is, if so, do the new allegations arise from the same or substantially the same facts as are already in issue? Now, we say that in relation to a new cause of action, there are the following very strong indications that there is a new cause of action. First, that the claimants have sought to introduce allegations of deliberate wrongdoing and deliberate exploitation of a conflict of interest. And in my submission, and I shall refer to one of the well-known authorities on this point, that is a very strong indication indeed that you are dealing with a new cause of action, and, for what it is worth, that it does not arise out of the same or substantially the facts as are already in issue. Because saying that someone did something negligently, the gravamen of the existing case was that you negligently failed to take steps to check with your client, GT, the basis for the signatures of Mr. Gormley and the witnessing of the signature by Mr. Downing. What is now said is an entirely different case.
Just on a point, our case is negligence, and that's been confirmed on numerous occasions. Our case is negligence, breach of duty.
Well, you can have a negligent breach of duty, or you can have a deliberate breach of duty. In each case, the cause of action is the breach of duty.
The cause of action against Rouse is that they failed to take reasonable care and skill, failed to accord with the code of conduct and so forth.
Could I ask the court to take out the authorities bundle and look at the decision of this court in Paragon Finance, which is at tab 4. Now, what happened in Paragon Finance was that the defendant solicitors were acting both for the claimant mortgage lenders and the borrowers in relation to the purchase and mortgage of a number of flats, and they were also and they were retained on terms which required them to advise of subsets. And allegations were brought against them in negligence and breach of contract, essentially for failing to advise the claimants of the existence of the subsets. And it was put on the basis simply, as just been discussed, of a negligent breach of contract. What then happened is that a certain case was decided in the House of Lords, namely Samco, which had the effect of radically restricting the amount of damages which would be recoverable in negligence. And so what was sought to be done was to introduce a whole series of allegations, both in relation to fraud and in relation to deliberate breach of fiduciary duty. And the Court of Appeal had to consider whether or not that was permitted. And you see the critical matter in just above the letter G of the head note. Subsequently, after more than 6 years had elapsed since the last relevant transaction and prima facie any applicable limitation period expired, the plaintiffs sought to amend their pleadings in order to allege fraud, conspiracy to defraud, fraudulent breach of trust, and intentional breach of fiduciary duty. And the head note records, for the purposes of Order 20 Rule 5, the amendment which sought to make a new allegation of intentional wrongdoing, where previously no intentional wrongdoing has been alleged, constituted the instruction of a new cause of action. Since intentional and unintentional wrongdoing give rise to distinct causes of action, it follows the amendment sought to be made by the plaintiffs introduced in the new cause of action. However, a claim based on allegations of fraud and dishonesty did not involve substantially the same facts as a claim based on allegations of negligence. Therefore, leave to amend should be refused. According to the plaintiff's appeal, would be dismissed.
Stuart, before you go any further, and this seems to be the only omission in my bundle, I am missing pages 18 to 37.
Oh. Does
You too? Yes, and my lord.
we've both of you. It would be a shame
Thanks very much indeed.
if, in accordance with the best traditions of the provision of bundle, the authority which I cite first is the one which we've managed to omit from your
We've got the first page.
Yes, we've got the head note.
I suppose that's better than nothing. Could you hand that up to the Justice?
Thank you very much.
The main judgment was given by Lord Justice Millett, and one sees him reciting certain well-known passages. If the court would go to page 22 of the bundle, page 405 of the report. he refers to Cook and Gill as the classic definition of a cause of action, letter D, and then he refers to Lord Justice Diplock's dictum in Latang and Cooper, simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against the other, and he identifies the issue in Latang and Cooper, which was whether or not a claim in negligence and trespass was the same. And one sees at the bottom, important to observe what Lord Justice Diplock was not saying. He was not saying that trespass and negligence are the same cause of action, or that intentional trespass could equally aptly be described as negligence, or a cause of action which was material to prove intent could equally well be described by the name of a cause of action in which it was not. That would not make any distinction, etc. And then it'll see, in my judgment, it's incontrovertible that an amendment to make a new allegation of intentional wrongdoing by pleading fraud, conspiracy to defraud, fraudulent breach of trust, or intentional breach of fiduciary duty, where previously no intentional wrongdoing was alleged, constitutes the introduction of a new cause of action. Now, just dealing with the present situation, what my learned friend is going to say, oh, well, these are all allegations of breach of contract. But what that doesn't deal with is that by introducing the TMA Code of Conduct and the rules in relation to conflict of interest, he is putting in place a plea, deliberately as you will have seen, that we intentionally acted in breach of conflict of interest where previously one hadn't done it. And in my submission, even if one says, well, they're both breaches of contract, that does not mean that they are the same cause of action. In order to succeed in relation to the plea which he has now put forward, he has to allege and prove, firstly, the existence of the TMA Code of Conduct, and therefore the express term which he now seeks to put forward, alternatively the implied term if he says that it's implicit from trademark attorney, that being different from the simple term relied on before of acting with reasonable care and skill. Secondly, he has chosen, for no doubt good reasons, in terms of what he considers to be the likely effect on damages, to allege that we did a whole series of acts intentionally in breach of conflict. Now, it sounds, frankly, far more like a case of breach of fiduciary duty. A duty of loyalty is a classic example of fiduciary duty. What my learned friend is really saying is that you acted in breach of your duty, knowingly in breach of your duty of loyalty to GT. That regardless of how it is dressed up, it is a different, materially different allegation. It's also obviously plainly more serious. Moreover, relied on in support of it are not merely the assignment of the trademark documents, the assignment documents as you saw previously, but a whole series of different acts and omissions in relation to a different period. So, for example, the assignments of the trademark documents will take place in April of 2012. They're now relying on active matters in relation to their complaints on a conversation which took place in August of 2012, and indeed on correspondence at numerous other dates. And so we say that when you look at this, if you stand back, you can see that what is being put forward is a wholly different case. It is a collection of facts which are substantially different and which are not all in issue on the present pleadings. And they are serious and of concern to us and have to be investigated in a way which they did not have to be investigated previously. If you look at what Lord Justice Diplock says just above letter E, paragraphs 10A and 15A2 allege intentional breach of fiduciary duty. Breach of fiduciary duty was already pleaded, but in terms which did not involve any conscious impropriety. the claimants submit the mere addition of an allegation of intent does not amount to a news of cause of action. In my judgment, that is contrary to the authorities already cited, which show that intentional and unintentional wrongdoing give rise to distinct causes of action. And we say that's directly applicable to the difference between an unintentional breach of contract and an intentional breach of contract.
Well, is that right, though? I mean, we've got that whole line of authorities in relation to the Section 32 of the Limitation Act, I guess like Beeman and Arts, where it's clear that if your cause of action is in, say, in conversion, the addition of the word fraudulent conversion adds nothing for those purposes. It's described as a mere epithet.
Well, my lord, two points in relation to that. Conversion, of course, is different from conflicts of interest and so forth. But secondly, Section 32 of the Limitation Act is different. What one is looking at in relation to Section 32 is under Section 32A whether or not you've got an action based on fraud. Based on fraud. The relevant statutory words. I think I have got Section 32 to hand, but the relevant statutory words here are addition of a new cause of action, not as in the case of Section 32. So I just want to remind myself whether or not Section 32 uses the. I think it's just an action based on fraud. Perhaps I could check.
Yes.
Rather
but that means where fraud is an element of the cause of action.
Yes, it does. Yes, it does.
I mean, the basic thrust of this case, the Paragon case, is that there were allegations made of fraud, introduction of pleadings of fraud, conspiracy, fraudulent breach of trust, etc. I mean, the one aspect which you've rightly lighted upon is turning a breach of fiduciary duty into an intentional breach of fiduciary duty. And does that give rise to a new cause of action? And as I understand it, what's being said here is that it is actually a different cause of action, quite clearly.
That's what Lord Justice Miller is saying.
But I don't draw from that, I think, the conclusion you're drawing, which is to say that a deliberate breach of contract is different to just a non-deliberate breach of contract. Just like a fraudulent conversion is a different cause of action to a conversion.
Well, my lord, there are 3 points in relation to that. The claimants have chosen, in the context of this matter, to allege reliance on express terms in the trademark. I need to be a bit careful. They've relied upon terms which they say are incorporated by the route which you've seen, which is the statutory route. Those include express terms which are in relation to integrity and also the creation of conflicts of interest. Those terms and that whole backdrop, in other words, what the breach of contract was completely irrelevant in relation to what was already an issue. For what it is worth, we had, of course, already admitted the general duty to act with the reasonable skill and care of ordinarily competent trademark attorneys. So they're adding a new allegation of breach of contract. First point. Second point, they have chosen to do that in the context of conflict of interest by saying that we did so deliberately. Now, that covers not merely that which they'd already alleged to be a breach of another term, namely the assignment of the creation of the assignment documents, but a course of conduct, which they say we were deliberately seeking to effectively hide this matter from the claimants.
Yeah.
Now, we would say that there is a material difference to that. One is a course of conduct which is aimed at a particular matter, and which therefore they'd say, no doubt, justifies the sums of money which they're claiming. The other raises all of the questions which we've already identified. Well, if it was forged and so forth, why did you not do anything about it? And the reason they've therefore made the difference is because they see it as being relevant to the change. And we say that when you therefore look at what the cause of action is, i.e. the facts necessary to prove it, they are different. The third point, maybe your Lordship's already indicated that you don't regard this as the most satisfactory, is that it is actually quite difficult to see why, if Lord Justice Millett is right that an unintentional breach of fiduciary duty is a different cause of action from an intentional one, an intentional breach of contract isn't different from a fiduciary one. But I accept that doesn't grapple with the
intention isn't in itself an element of a cause of action of breach of contract. Whereas what I understand the paragraph is saying is that intention may be an element in relation.
Well, what they were trying to do in Paragon, because Paragon was at a time when the precise ambit of what the House of Lords had decided in Samco wasn't there, was to run an argument that you couldn't have a scope of duty defined. It wasn't even referred to as scope of duty in those days, but you couldn't have a scope of duty restricted when you had an intentional breach of contract. That's what they were aiming at. So there was a reason for them doing what they were doing, just as I would say there's a reason for my learned friend doing what it is that he's doing here.
Yes. There's always a difficulty when you've got very substantial amendments, somebody coming along and saying, well, they're introducing nothing new.
Well, so that point is a point which I've, of course, adopted, my lord. Sorry, there's one other passage I just wanted to. I just wanted to refer to Lord Justice Pill at page 36. Who expressly agrees between G and H that an amendment to make a new allegation of intentional wrongdoing by pleading fraud, conspiracy to fraud, fraudulent breach of trust, or intentional breach of fiduciary duty where previously no intentional wrongdoing being alleged constitutes the introduction of a new cause of action. And he expands on that slightly over the page at page 37. And one sees him dealing in little e with Latang and Cooper, and that's of course the negligence trespass case. To allege that an injury is caused intentionally is to add a new allegation of fact which gives the allegation of fact as a whole a substantially different character. In Latang and Cooper, this court recognised the division in actions for personal injuries according as the defendant did the injury intentionally or unintentionally, and relied on what Lord Dunning said. The state of a man's mind as a matter of fact is the state of his digestion. It's a matter of fact as anything else. The addition of allegation of intentional wrongdoing take these cases beyond the power conferred because the claims do not arise out of the same facts or substantially the same facts. Now, I accept first of all that he's dealing with two different questions there. He's dealing with the cause of action point upon which he agrees with Lord Justice Millett, and he's dealing with the same or substantially the same facts. But I do say that you have got, well, all three members of the court, because Lord Justice May also agrees with both of them, highlighting the importance of intention. And to make the obvious rhetorical point, if there's no difference, the allegation shouldn't be in the pleading in any event. But the substantive answer to my Lord Justice Phillips' points were in the 3 points I've put forward. The third rests upon the reading of the Court of Appeal. The first two are the substantive argument as to why I say it's relevant. Now, the second aspect I've already really touched upon, and the court's already seen the very substantial expansion of the case against my clients simply from you did the unauthorised transfer of the assignment documents, limited in time, limited in nature, to a wholesale course of conduct over a much more substantial period of time, and including specific allegations of fact. I mean, just take the August 2012 telephone call. That telephone call is now expressly pleaded. It said that we had the telephone call, and then we took deliberate actions in order to effectively undermine the claimants. We didn't have any previous basis to look at or consider that telephone call. It doesn't arise from the same or substantially the same facts as are already in issue on pleadings. It's an entirely new set of averments. It's in relation to a matter which is now 11 years old, and we say that it undermines the statutory purpose if one is going to allow that amendment to be made. I only propose to refer to one other authority.
This is a point on same or substantially the same facts, is it? You're not taking a discretion point that even if it was within the test, it's all so long ago it shouldn't be allowed to natural discretion.
Well, the answer to that is the gravamen of my point. So the two same cause of action, they fall into that hall, not sustain or substantially the same. So I say there's no discretion. Frankly, I'm not sure whether it certainly has not been the focus of my argument to focus on discretion at that stage.
I'm not sure it's within your grounds of appeal.
I was just going to say that I'm not sure it's within my grounds of appeal. I rather suspect that if I'd fallen the first two hurdles, I'm unlikely suddenly to be able to leap up and get over the third one. But to answer your lordship's question directly, it goes both, I say, to cause of action and to sustain or substantially the same facts. So it goes to both the first two elements of the test. My lady, my lords, I was going to refer to one other decision in this context. The court will know there is a vast number of authorities in relation to addition of new causes of action. I was pleased to see that one of the cases which I did, I think, very shortly out of pupillage was in there, Parsons, Brown, Newton, which was then it was now some 35 years ago. But I propose simply to ask your lordships to just look at a couple of observations which we see in a recent decision of this court, which is Mullally and Martlet Holmes, which is at tab 18 of the bundle. Now, Mullally is in a different context. It's in essentially the building context. And one of the issues which has long troubled the courts is a situation where you have a building contract and you allege that the builder did A, B and C wrong, and you then want to allege that he did B, D wrong as well. And going back to decisions which are now really quite old, Steamship Mutual and so forth, the court has effectively said in relation to that it's a question of fact and degree, and you look and see what the breaches are. If you're saying, well, the floor was broken in that room, but it's also broken in that room, it's one thing. If, on the other hand, you make allegations about the roof, and then you come along and make allegations about the foundations, that's likely to be a different matter. So that's the context, the overall context in which this discussion is taking place. The Court of Appeal starts to deal with the law at page 351 of the bundle, paragraph 40 and following. And in doing so, they cite with approval a passage from Lord Justice Tomlinson in Cooperative and Burse at paragraph 44, And what is said, in the quest to what constitutes a new cause of action, a cause of action different from that already asserted, it's the essential factual allegations upon which the original and the proposed new or different claims are reliant which must be compared. Thus, the pleading of unnecessary allegations or the addition of further instances or better particulars do not amount to a distinct cause of action. See paragraph on finance. So in identifying a new cause of action, the bare minimum of essential facts abstracted from the original pleading is to be compared with the minimum as it would be constituted under the amended pleading. See per Lord Justice Robert Walker. The Court is therefore concerned with the comparison of the essential factual elements in a cause of action already pleaded with the essential factual elements in the cause of action as proposed. See per David Richards. A change in the essential features of the factual basis, rather than, say, giving further particulars of existing allegations, will introduce a new cause of action. Now, applying that here, what we had previously were allegations in relation to the trademarks, the creation of the assignment documents. And if, as they have done, they provide particulars that not only did we assign the Japanese trademark, but we assigned an Indian trademark, so be it. That's a matter within the same compass. However, what they're doing here is way beyond that. They're not confining their case to the assignment documents. Rather, they are complaining about a whole series of matters where we consciously preferred, on their case, the interests of a client adverse to those. Some of which they say happen also to be the assignment documents. And so coming back to the example I just looked at, but one can take it in relation to any of them, the August 2012 telephone call. That has, we say, nothing to do with what was originally pleaded. The gravamen is not that you did the assignment. The gravamen is that you phoned up to warn someone else, actively damaging our interests. And we say that is a completely different factual basis for what's being put out. It requires new facts to be alleged, obviously. The existence of the telephone call itself, not previously pleaded. The alleged intention, not previously pleaded. And so we say that it falls within that classic definition of a new cause of action. And we also say, for the same reason, it doesn't arise out of the same or substantially the same facts. And then we see the court grappling with the fact that the courts had sometimes had difficulty in deciding whether a new cause of action had arisen in circumstances where different facts were alleged to constitute a breach of an already pleaded duty. And he goes back to cases such as Steamship Mutual, which I referred to, and refers to them being a question of fact and degree. For my part, I'm not convinced one needs to look further for a change in the essential features of the factual basis relied upon. Bearing in mind the factual basis will include the facts on which the duties be spelled out, as well as those which allegedly give rise to breach of damages. And he then goes through and deals with the building cases a little bit more. And if I could just pick it up under the heading same or substantially the same facts at the bottom of 353, where he's referring to judgment of Lord Justice Tomlinson and Ballinger and Mercer. And he refers to two different decisions, Good and Martin and Lloyds Bank and Rogers, and then goes through and identifies Lord Justice Millett's observations, and then his conclusion at 50. I'm not sure with respect how far these various observations really take us, though it's important to stress the point at 37 of Lord Justice Tomlinson's judgment, namely that substantially the same is not synonymous with similar. The point being made there is that it's a pretty high statutory test. And he then goes through and identifies various cases, including Libyan investments. And his conclusion at the paragraph 53, the appeal against that decision was allowed, Lord Justice McComb said the new claim is based on allegations knowledge to be inferred from a multitude of facts said to have been known at before a source of inquiry said to have been undertaken in a very lengthy period. He found at paragraph 46 it's fanciful to assume the detailed facts now alleged would already have been investigated, at least to the extent that the claimants were now contending. He concluded at 49 that the judge didn't conduct any real evaluation of the new claim against the facts. And then this, as I think Lord Justice Sales was saying in the Mastercard case, it's necessary to make an evaluation of the new case as against the old case in order to ask the threshold question whether the new case arises out of the same or substantially the same facts. At 50, he undertook that exercise, including the new claim did not arise out of the same or substantially the same facts. And then he says that's an example of existing principles. Now, what I say you get from that is that you have to stand back and look at the allegations which are made. You have to say, do these arise out of the same or substantially the same facts? I say that when you look at the detail of those allegations, you see that they don't. And you can also see that there are a whole series of factual matters which, if these are allowed in, we will be required to investigate, which we would not have been required to investigate beforehand. And that means that there is no discretion to allow these matters in. And when that is done, we are then thrown back in relation to the pleading with the allegations of breach having, new allegations of breach having gone, save insofar as they're simply related to trademarks. And you have nothing in the pleading which allows you to link through to answer the how question, which I started off my observations to the court about, and therefore we say this claim should come to an early demise. I just check with those behind me that there are no further points, and subject to any observations from the court.
Just one question. Could you look at tab 16, page 230 of the main bundle?
Yeah, of course.
Justice Nugie's order records that this case falls within the Court of Appeal mediation scheme and that there is no reason not to refer it to mediation. What happened?
Sorry, I'm turning my back this time. I'm told that there was a joint letter from the parties to the court saying that it was the view of the parties that it was too complex for the mediation scheme. I don't have a copy of that letter to hand, but I can investigate the position over the short adjournment.
All right, well, perhaps that could be provided.
I might be able to add to that. After the judgment, the parties were very close to starting a mediation, and indeed were discussing dates and potential mediators.
I mean, I don't want to be told anything about the content of any.
No, that was being explored. The granting of permission brought an end to that attempt, unfortunately.
Very well. Yes.
Sorry, I've sat down.
No, my apologies, Mr. Stewart. I was just conferring with my lord to see if he had any questions at this point. No. We have no further questions at this point. We'll just rise for 5 minutes, then come back.
Does it feel a bit cooler in here, or is it not? I said they're working on it.
deal first with some points on background, then causation, and then balance. One or two points on the background. Mr. Stewart did spend some considerable time going through the procedural background to the case. My submission, that is no part of any of the tests that this court needs to look at today. It was a major plank in his case before the judge that discretion and delay and so forth should all count against me. But as far as the grounds of appeal are concerned, the procedural background, whilst not pretty, and I accept there are things in this case which mean that the pleading is not pretty, the background does not reflect well on the parties. That is put forward in some detail, but of no help to you at all, because it's not part of the grounds of appeal. It's not part of the tests that Mr. Stewart has rightly outlined to you. In relation to the factual background, you will have seen that the Rouse defence effectively rests on a plea that they understood that they could take instructions from the conspiracy defendants, because the conspiracy defendants and their company Davies were in a joint venture with GT. And the defence pleads at a number of occasions that Rouse understood that it was acting on the basis of instructions from the joint venture. And you will have no doubt noted that the conspiracy defendants did plead a joint venture in the unsuccessful Northern Ireland proceedings, but have not pleaded a joint venture in these proceedings. They don't say that it was a joint venture. The claimants say that there was no joint venture. And you will also have noted the claimants' inquiries of Rouse as to on what they base. What agreement do they look at to base the existence of a joint venture on the basis of which they can make act to transfer the intellectual property rights and indeed the whole business out of GT's name into the name of Holdings.
To what extent do we look at the defence, either of the conspiracy defendants or Rouse, in answering the questions on the appeal? So far as whether it's a new cause of action, I would have thought not. To the extent that there may be a question about what facts are in issue, then I suppose we could look at defences for that purpose. But I mean, Mr. Stewart hasn't really developed any argument
My Lord,
along those lines.
this is a bit of a jury point, I accept. I say the reason why Mr. Stewart's focus before the judge and before this court is all on causation is because that's all that the Rouse defendants have got. The case on breach of duty and negligence is hopeless, because the one thing on which they say they acted doesn't exist. A joint venture on which they could properly take instructions from the conspiracy defendants and didn't need to consult their clients, GT. So that is why we have this somewhat desperate appeal, because without a causation defence, Rouse are nowhere. That's why it's also...
I'm not sure who's making the jury points. Is it you or Mr. Stewart?
Yeah. Well, both of us to this extent. But I accept that this is a bit of a... this is why it focuses on causation. And why at this stage? Because, of course, once this gets to trial, it will be obvious on the evidence that the Rouse negligence in allowing the trademarks to be put in the name of a third party so that the world could see that apparently the conspiracy defendants company owned this business, not my client, the claimant. Well, it's obvious that's going to interfere with my client doing business deals with its customers. His customers will say, well, hang on, you're not you're not registered as owning the rights to sell this product. And these conspiracy defendants who have called us, well, we've looked at the register, they do have it. So that's why this is an all or nothing for Rouse, we say, before the judge on a strikeout basis, to try and say, let's try and get rid of this at a preliminary stage, because if this comes to trial, this isn't going to wash.
You say it would be obvious that the world would see that the conspiracy defendants company owned the trademarks, and that would interfere with the claimant's business. Obvious or not, was that pleaded before the green amendments in the draft re-amended particulars of claim?
Was it pleaded before the draft?
I mean, I can see there are paragraphs. I think it's subparagraph L under the heading of breach rather than causation, but
yes.
Nevertheless, it seems to be there. But was it there before?
In the old pleading, the old pleading was, Rouse, you allowed trademarks to be registered in somebody else's name. You facilitated that. We tried to do business with our purchasers. The conspiracy defendants said, we own the company, we own the rights, and those purchasers fled. As a matter of common sense, as a matter of obvious sense, I say in the earlier pleading, the authoritative platform that owning trademarks and having trademarks registered in your name gives to the conspiracy defendants was obvious. But as you've seen, Rouse said, well, exactly how is it that our default in allowing these trademarks to be registered in somebody else's name?
Right. Well, if you could show us at some point where that authoritative platform point was pleaded in the original pleading, I might be quite helpful.
Well, the words authoritative platform are how we formulated it, how Ms. Green and I formulated it in the pleading for which we're responsible.
Yes, but if you show us the equivalent where the point is made, that would be helpful.
But no, it's not said that the appeal on causation, we look at the new pleading. We don't need to look at the old pleading in relation to causation, because the question was the judge right to say, on the pleadings as they are now, i.e. the re-amended particulars of claim, is there a pleaded case on causation? That's the question. So I would push back to this extent. It doesn't really matter whether or not the causation case was properly or effectively pleaded in the earlier pleading, because that's history.
Well, that's up to you. I've said it would be helpful to be shown. You either show me or you don't.
No, I will show you, but I'm making that submission in order to say on the causation appeal. That's where, and I think Mr. Stewart and I agreed on that. The judge needed to look at the pleading as it is today to see whether causation was pleaded. That deals with the background. Next, on going to causation, first of all, it is correct, as Mr. Stewart says, that there is nothing between us on the applicable law. He has cited, and we do too, Towler and Wills, the passages that are highlighted for you from that and from Pantelli Associates. What is required is basic. It is, I don't know if I need to actually take you to the case. It's whether the Rouse understands the causation case so it may plead to it in response. So it may disclose those of the documents which are relevant to the case and prepare witness statements which support the defence. The judge looked at the draft re-amended particular claim and said, that he was able to understand it, and said that Rouse was able to understand it and able to plead to it. This appeal is that the judge was wrong about that you can't look at the the causation case on the re-amended claim and understand it so that you can respond to it. One case that Rouse relies on in its skeleton that we haven't dealt with in all submissions is Brewdog and Frank Public Relations. That's a case which is in the bundle at tab 15, beginning at page 260. The principles that are agreed are those set out at page 270 and 271 and are sidelined.
Sorry, which page?
270 and 271 are the ways in which, in this case, the claim in negligent misstatement.
Nothing
Mr.
sidelined in mine.
No, nor mine. I think you'd better take us to the relevant parts.
I apologise, there was a sidelining version. It may
It's
be that
probably in the other file
your
that we've
bundles have
given.
been created. I apologise. Well, let's go back to the beginning.
It's sidelined on the electronic copy that I have.
Well, just tell us where to put
Yes,
the
of
slide.
course.
Can I ask whether, sorry, I don't interrupt, but can I ask whether two members of the court haven't got any sidelining in their bundles? Because if so, something has gone wrong. There has been quite extensive sidelining done.
Why don't I, because I just billeted the bundle that was handed up to put in the missing pages in my own bundle. Let's see what's here.
Marlowe Jr. and Nat Malone Friend have done quite a lot of work on the sidelining, and they actually reached agreement as what, so it would be a shame if that work.
Can I just say, the sidelining is in the bundle that I've been handed this morning, so I'll just go to that.
Well,
So I did
lady,
find all the
if that would be convenient, then,
Yes, sir.
then at least you've got
Yes,
that.
of course. And I wouldn't want all the time and effort spent by your respective juniors to go amiss.
So the case was the principles are the same. The pleading understandable? That's the principle in Brewdog. It's important just to go back to page 261 to see, well, what sort of case was it, and why is it that the pleading is not there? It's a libel action, a slightly unusual libel action, in that Brewdog had engaged the defendant, Frank Public Relations, through a third party to give PR to the launch. You'll see in paragraph 3 on page 261, 6 promotional events to launch this beer in various places in London, Leeds, Manchester in 2018. And paragraph 4, that Scofflaw, the third party, engaged the defendant to promote relationship. The press release that came out said that the free beer was being offered to UK Trump supporters and was fairly disagreeable about the idea that the beer was being drunk by rednecks who supported Donald Trump. The claimants were very unhappy about the characterisation of this, and the press release was withdrawn, but the damage had already been done, said the claimants. If you look at paragraph 13, the claim relies on defamation and negligent misstatement. The couple of pleadings of defamation, which are set out in paragraph 14, which effectively was that associating the beer with supporters of Donald Trump was itself defaming Brewdog. And in short, the judge found that, well, it wasn't defamatory, in that some people would have thought that that was associating the beer with positive political aspirations, and other people might assume that it was negative, but it wasn't a defamation. And then the second claim was in negligent misstatement. The meaning of the words complained of and the defamation is dealt with in paragraph 20 onwards. We don't need to look at that. That's the case in libel. The strikeout of the pleading begins at page 267 and paragraph 29. The summary on behalf of the claimant, paragraph 30, is that the pleaded natural and ordinary meaning claimants of support of Donald Trump did not disclose reasonable grounds for bringing the claim in libel. Wasn't reasonably arguable that the meaning was defamatory. The innuendo meaning didn't disclose reasonable grounds. 2, little 3, the innuendo didn't accord with the practice direction. The judge looked at paragraph 32, the test for defamation, paragraph 34, the test for innuendo. Then we get to paragraph 37, which is the part that should have been sidelined. That's down to paragraph 45. Mr. Glenn's right to say that the pleading of the cause of action is deficient. Doesn't presently plead the facts and matters on the basis of which it's alleged that the defendant owed a duty of care. So that a duty of care wasn't pleaded, the facts and matters for the duty of care weren't pleaded. It doesn't plead the ways in which it's alleged that the defendant was in breach of its duty of care, i.e. what facts and matters were alleged to constitute negligence. It doesn't plead the loss which the claimants alleged to have suffered as a result of the defendant's alleged negligence. Paragraph 38 suggests that parties are not obliged to plead law. Well, as Mr. Glenn submitted, middle of that paragraph, the alleged duty of care would be novel and a substantial extension of the current duties of care. Whether such a duty of care is owed would be ultimately determined by the court. But Mr. Glenn is correct that the defendant is entitled to know the factual basis on which the claimants will contend that such a duty was owed to them. I also agree that petitioner's claim do not currently explain how it's alleged that the defendant was in breach of the duty of care. Mr. Street says it's self-evident. With respect to him, I don't agree. The defendant is entitled to know precisely how the claimants alleged that it failed to exercise reasonable care. For instance, paragraph 28 says that the press release was untrue. That does not tell the defendant in what respect the press release was untrue, nor does it tell the defendant in what manner the defendant failed to take reasonable care to see that the press release was true.
What's the proposition of law for which you're citing this case?
So the proposition of law which is put forward is that a pleading is deficient if it is such that the other party cannot understand the case against it and defend it. And you'll see that in this case, the deficiency is really very substantial. The claimant had pleaded a duty of care without giving any indication on what duty of care was based, pleaded breach without saying exactly what was breach, what part of the statement was untrue, and failed to plead loss as well. And therefore, in my submission, this is plainly a case in which you look at that. This is the threshold. Do you look at the pleading and say, well, I can't plead to this because I just don't know, I can't properly understand what the case is against me. So I say proposition on which both parties cite, the understanding proposition, is common. But this case is a classic case in which the pleading can't be properly understood or responded to. And it's a world away, an absolute world away from our case. What I say about our case is this. And it's useful at this stage just to take you to a couple of documents that Mr. Stewart took you to, and just to look at those parts of the documents that he may have I would like to draw your particular attention to. But, the question is this a case in which the pleading of causation is unintelligible? A person reading the pleading, the draft re-amended particular claim, cannot tell what the essential case on causation is. We say that when you read the draft re-amended particular claim, with or without the schedule of loss, any reader would effectively say that the breaches that are alleged against Rouse gave the conspiracy defendants the opportunity that they wouldn't otherwise have had of telling the purchasers that the intellectual property rights were owned by them and not by GT. That's effectively the causation case. What we've called the authoritative platform, because owning trademark rights and having a trademark in your hand or on a trademark register is an authoritative indication that you own or you control the product for which the trademarks are registered. Mr. Stewart did take you to the letter in the supplementary bundle at page 226, in which Appellant Co on behalf of Rouse raised the issue of causation in November 2020.
Just before you go there, in your formulation a moment ago, you said with or without the schedule of loss. Perhaps you'll tell us at some point what is your submission as to the current status of the schedule of loss, whether, as I suggested to Mr. Stewart, it's been superseded, or whether you're going to say they live together in some way, and if so, how you resolve any inconsistencies between them.
And in short, the re-amended particulars of claim, the draft re-amended particulars of claim, were intended to come after and to respond to the complaint raised by Appellant Co on behalf of Rouse, saying your causation plea is in, we understand it, but it's in multiple documents. It should be in one place. And so it supersedes it, is the short answer. But if I can take you to 226, you'll see there that at 226 of the supplementary bundle, in November 2020, Rouse sees the responses that Mr. Stewart took you to and the schedule of loss that we just discussed. It comments on causation in paragraphs 1.1, 1.2, 1.3. At the bottom of the page 226, the last line says this: "You will appreciate it that it will be for your clients to establish on the balance of probabilities that those alleged losses would not have been suffered in any event, even if the allegations of breach against Rouse succeed. As we discussed below, it is readily apparent to us that your clients have failed to set out their position because they are unable to show that the losses complained of would have been avoided but for those alleged breaches. You say at paragraph 20 of the schedule of loss that potential business relationships were soured by the conspiracy defendants threatening injunction proceedings against US businesses in reliance on the assignments drafted by Rouse. All reputation and goodwill generated since 2008 was lost, and the co-defendants created negative publicity from the marketing campaign. However, on your client's case, on your client's own case, 1.5.1, the assignments were forged such that they would be void. Just on that point, the fact that they were forged at the time when the profits were lost, there were apparent documents, there was an apparent registration, and there was an actual registration. The apparent documents were the ones that caused the purchasers to run away. The fact that there was authoritative registration of them, so the fact that they could have been declared void at a later date, did not stop the loss of profits at the time when it occurred. Because the claimant says, we had this miracle fertilizer product ready to ship. We had the rights, the exclusive rights to sell it. We had in the US Mr. Machado, who was ready to buy it in significant quantities. We had the other buyers who were listed in the schedule of loss lined up. And they were scared away in 2012 by the co-defendants, the conspiracy defendants, and the conspiracy defendants were able authoritatively to scare those people off because they apparently did own the rights to the product at that time. So the fact that they could have been declared void at a later stage by the court, by that time the ship had sailed on these profits.
I think, as Antonio, the point made against you there in this is it said, well, plainly the core cause, the sine qua non of this transfer of your rights into the names of the conspiracy defendants was the forgery of your authorised person's signature.
Yes.
Without that, none of this could have happened. The question then was, well, what is the role of Rouse in this? Could the conspiracy defendants not have gone to any patent attorney and said, please will you draft these assignments and have them registered? If Rouse didn't know about the forgery, how is their role an operative cause if what's really the cause is the forgery? And perhaps you can answer me, A, what is it, and have you pleaded it?
So the answer to that is that Rouse has admitted that its client is GT.
Yes.
So its client's GT, it gets a apparent assignment signed by its client, and it gets a counterparty signed by Holdings, and it affects the transfer document.
But what if Rouse had said, GT's my client, I'm not prepared to deal with this? What would then have happened?
What we're saying is this. Any other solicitor or patent attorney would have asked its client, is this right? You want to assign, you are giving me instructions to assign these rights to a third party. And they would have contacted the directors of the client to get instructions from their client. They wouldn't have taken instructions from the conspiracy defendants, who were the director of Holdings, the company that was taking the transfer.
So what? This is your original due diligence point, is it?
Exactly right. This is in the original pleading, Rouse acted without authority, acted without checking its clients, and its defence is, oh, we did have authority because we didn't need to hear from our client that it wanted to transfer away these valuable rights, because our client had given the conspiracy defendants authority to speak and give instructions on its behalf, because there was this elusive all joint venture that Rouse seems to have says that it assumed was in place. But any other solicitor or patent attorney who had been asked to do the same thing would have said to GT, do you give us instructions to transfer your intellectual property, your trademarks, to this third-party company?
And is that something you pleaded?
Yes.
Where do we find that?
Can I finish on this page and then
Yes, sure.
and then go to it? And because what I was going to do is go through the pleading and answer to yours and to my Lord Justice Mayall's question. So, if we look at just going back to 227, on your client's own case, as we understand it, you say that the breaches alleged against Rouse gave the co-defendants the opportunity falsely to say that intellectual property rights had been transferred. Well, yes, that is our case. At its the highest level of abstraction, which is some language from the other authorities we looked at, that's what we say. That is the defendant correctly understanding the case against us. Now, for the reasons that we've just been discussing, that case may be one that is successful at trial or maybe unsuccessful at trial. But there's no doubt about it that Rouse have looked at the pleading and they've understood the case they have to meet, because they then go ahead to label 3 points which they say upset and or defend that causation claim, because they say, well, the Irish proceedings would have done that anyway. They say B, your clients were in a position to challenge the assignments from August 2012 when they became aware of them. And C, well, the operative clause of the losses would be the fraud of the co-defendants in any event, because, and that's the point I've just discussed with Lord Justice Phillips, they say this plainly could have taken place without our client's involvement. They're going to say, well, another solicitor would have done the same, and therefore what we've done was not causative. So they know the case against them as of November 2020, and that's why I say this is a tactic on part of Rouse to say we don't understand the causation case against us, but I say it is understood and it's there in the pleading. So let's look at the pleadings now. The way that this is put in the grounds and in the Mr. Stewart's argument is that there are 2 errors made by the judge in relation to the allowance of the case on causation. They are, in short, that the schedule of loss is not an appropriate place for a plea of causation, number 1. And number 2, the second, what they call the key errors in their skeleton argument. First key error is the schedule of loss is not an appropriate location for a plea of causation. And the second error is that the judge impermissibly relied on the allegation that because of what Rouse did, GT lost its entire business, including the exclusive sales, marketing and distribution rights of the product, and the judge impermissibly relied on the April 2011 agreement. So those are the 2 points that are made against the judge, which I have to respond to. But Mr. Stewart rather opened that up in orally and effectively said, more than that, on a fair reading of the pleading generally, we still can't understand the case of causation, even though, as I've sought to point out, they have understood it, and indeed they've accurately summarised it and started responding to it. Let's go first to the place as it is at the moment, the present position. What we have sought to do is to do a pleading in the traditional way, which is effectively to say, this is what you did wrong, in detail. This is what you did that you shouldn't have done. This is what you didn't do that you should have done. We've set out loss in some detail, and then the causation paragraph is a very short one. By reason of your breach of duty, you've caused the loss. And of course, that's conventional in pleading terms. What it's important to do on the case of causation is for you to be able to see from the nature of the breaches of duty, the negligence pleaded, that those are the sorts of breaches of duty that cause or contribute to loss. What we haven't done and this may be a stylistic difference between Mr. Stewart and I, we haven't pleaded a long causation paragraph saying these are all the parts effectively repeated from what's been said before, which are our case on causation. In hindsight, maybe this has been such a point that's been made against me that it may have been better for me to adopt a different stylistic approach to this particular amendment of pleading, but I've done it in the way that I've described, and in my submission, it is perfectly clear why the types of negligence and breach of duty that we allege provide the authoritative platform. So,
Mr. Burns, we're shortly before 1 o'clock.
yes.
When would be a convenient moment? Because if you're going to go now, which I think you are,
Yes.
aren't you?
Lady,
Deal
you're absolutely right. I'm just about to
specifically with the pleading.
launch into
Yes.
the pleading, and it's probably better to do that when we have a full opportunity to look through it together.
All right, we'll rise now and we'll start again at 2 o'clock. Thank you.
All rise.